Have you ever watched someone realize in real time that they made the worst decision of their life? Not in hindsight, not looking back years later with regret, but in the actual moment when the consequences become unavoidable and irreversible. I have seen it happen in courtrooms more times than I can count. But yesterday was different because the realization did not come during a verdict. It did not come during an arrest. It came during sentencing. After everything was already decided, after all the opportunities to cooperate had passed, after the window for a plea deal had closed, the defendant stood there listening to the judge read through the sentencing calculation and suddenly understood that this was real, that he was going to prison for decades. And in that moment of desperate clarity, he broke. The sentencing hearing had been proceeding normally for about 40 minutes. The judge had reviewed the pre-sentence investigation report. She had heard from the prosecution about the scope of the fraud, the number of victims, the amount of loss. She had listened to the defense attorney argue for a sentence at the low end of the guidelines, standard procedure. Everything was following the expected pattern. The defendant had been standing at the defense table with his attorney, hands clasped in front of him, facing the judge, waiting for the inevitable. Then the judge began walking through the sentencing factors. She discussed the nature and circumstances of the offense. Multiple counts of fraud over several years, systematic deception. She talked about the history and characteristics of the defendant, no prior criminal record, but also no genuine acceptance of responsibility. She addressed the need for the sentence to reflect the seriousness of the offense, tens of millions in losses, institutional trust undermined. She mentioned the need to provide just punishment for the offense, the need to afford adequate deterrence, the need to protect the public. With each factor, you could see the defendant's posture change. His shoulders started to sag, his breathing became faster. By the time the judge reached the calculation of the guideline range, he was visibly trembling. The judge stated that based on the total offense conduct, the applicable guideline range was 30 to 37 months. But she continued, she said that given the aggravating factors in this case, she was considering a sentence above the guidelines, significantly above. That is when everything shifted. The judge said she was contemplating a sentence in the range of 20 years in federal prison for fraud. The defendant's knees buckled slightly. His attorney grabbed his arm to steady him. The judge continued speaking. She said that the defendant had shown no remorse throughout the trial, that he had lied on the witness stand, that he had attempted to destroy evidence when the investigation began, that his conduct demonstrated a level of criminal intent that warranted a substantial sentence. The defendant started shaking his head, not dramatically, just small movements, whispering something to his attorney. The attorney whispered back. The judge kept talking. She referenced specific victims who had lost their savings, employees who had lost their jobs when the fraud collapsed. She said the sentence needed to send a message, and then she said the words that triggered the breakdown. Based on all factors considered, this court sentences you to a term of 22 years in federal prison. The defendant made a sound, not quite a scream, not quite a sob, something between the two. His attorney put a hand on his shoulder. The judge continued with the standard language about credit for time served and supervised release conditions. But the defendant was not listening anymore. He turned to his attorney and said something. The attorney shook his head, said something back. The defendant's voice got louder, loud enough that people in the gallery could hear fragments. "Tell her, I can help, I know things." The judge paused. She had been reading from her written sentencing statement, but she stopped, looked up. The defendant was now fully turned toward his attorney, gesturing emphatically. The attorney was trying to calm him down, trying to get him to face forward, but the defendant pulled away. He turned toward the judge and he screamed. Not words at first, just a raw sound of desperation. Then words started coming, loud, frantic. "I'll tell you everything now. I'll cooperate, please. I know names. I have documents. Just give me a chance." The judge raised her hand. "Sir, you need to compose yourself." The defendant ignored her. He kept talking, shouting, "I can give you the accountant, the lawyer who set it up, the bank executives who knew everything. Just please, not 22 years. I'll tell you everything." His attorney was pulling on his arm, trying to get him to stop, but the defendant was beyond listening. He had gone from composed to completely unraveled in the span of 30 seconds. The judge struck her gavel once, hard. The sound echoed through the courtroom. "Mr. Johnson, you will stop speaking immediately or I will have you removed." The defendant finally went quiet, but he was still standing there, breathing hard, tears streaming down his face. The judge looked at him for a long moment. Then she spoke in a tone I have rarely heard from a judge. Not angry, almost sad. Mr. Johnson, the time for cooperation was 2 years ago when you were first approached by federal agents. It was 18 months ago when you were indicted and offered a plea agreement. It was 1 year ago when the prosecution made a final offer before trial. It was 6 months ago during trial when you could have stopped lying and started telling the truth. The time for cooperation is not now. Not after a jury has convicted you on every count. Not after you have forced the government to prove its case through a lengthy trial. And certainly not after I have announced your sentence. She paused. Let that sink in. The defendant was just staring at her. The judge continued. You had countless opportunities to do the right thing, to accept responsibility, to cooperate with the investigation, to help identify other wrongdoers. You chose not to take any of those opportunities. You chose to lie, to obstruct, to fight every step of the way. And now, when faced with the consequences of those choices, you want to cooperate. That is not how this works. The courtroom was completely silent. The judge looked down at her sentencing statement. The sentence of this court remains 22 years in federal prison. Marshals, please take the defendant into custody. 2 U.S. Marshals stepped forward. The defendant started pleading again. Please, just let me talk to the prosecutor. 5 minutes, I can give you so much information, please. But the marshals were already guiding him toward the door that leads to the holding cells. His attorney followed, trying to speak to him, but the defendant was still shouting as he was led away. I'll cooperate. I'll tell you everything, please. The door closed. The courtroom remained silent for several seconds. Then the judge addressed the prosecutor. Counsel, I assume you heard the defendant's statements. The prosecutor stood. Yes, Your Honor. The judge asked, is there any interest from the government in pursuing cooperation at this stage? The prosecutor was diplomatic in her response. She said the government always welcomes cooperation, but she noted that the defendant had been given multiple opportunities over 2 years, that he had rejected every offer, that he had actively obstructed the investigation, and that any cooperation now would be evaluated in light of his long history of non-cooperation. Translation: too little, too late. Let me explain what just happened from a legal perspective. The defendant thought he could beat the case at trial. He thought the jury would acquit, or at worst, convict on some counts, but not others. He gambled that the evidence was not strong enough. He lost that gamble. Then he thought that even if convicted, he would get a relatively light sentence, maybe the low end of the guidelines, maybe even below guidelines. He gambled that his lack of criminal history and the non-violent nature of the crimes would work in his favor. He lost that gamble too. And now, facing 22 years, he finally realized he should have cooperated from the beginning. But by this point, his cooperation has almost no value. Here is why. When someone cooperates early in an investigation, they can provide information that helps build the case. They can identify other targets, explain how schemes worked, point investigators toward evidence they might not have found otherwise. That kind of cooperation is valuable. The government rewards it with substantial sentence reductions. But when someone waits until after they have been convicted and sentenced, their cooperation is worth much less. The case has already been proven. The defendant has already been found guilty. There's no trial to help with, no plea agreement to negotiate. Any information the defendant provides now will be viewed with extreme skepticism because it comes from someone trying to reduce their sentence after the fact. Additionally, defendants who cooperate late lose credibility. If you spent 2 years lying and fighting, why should prosecutors believe you are suddenly telling the truth now? You have demonstrated that you will say whatever serves your interests. How can anyone trust that the information you are providing is accurate and not just more lies designed to manipulate the system? This credibility problem makes late cooperation difficult for prosecutors to use, even if the information is valuable. There is also a practical problem. Federal sentencing happens quickly. Once a judge announces a sentence, it is final unless there are specific legal grounds for reconsideration. The defendant cannot just offer to cooperate and expect the judge to reduce the sentence. There are procedures that must be followed. The defendant would need to provide substantial assistance that leads to the prosecution of other individuals. Then the government would need to file a motion for downward departure based on that assistance. Only then would the judge have the authority to reduce the sentence. That process takes months or even years, and it only happens if the cooperation is genuinely valuable and the government chooses to file the motion. What I witnessed yesterday was a man who made a series of calculated decisions that turned out to be catastrophically wrong. He decided to reject the initial plea offer that would have resulted in a 3-year sentence. He decided to go to trial and lie on the witness stand. He decided to force the government to spend resources proving every element of every charge. And now he is facing 22 years instead of 3. That 15-year difference is the price of his decisions and screaming, "I'll cooperate." in the middle of a sentencing hearing cannot undo those decisions. Let me address what you might be thinking. Is it fair that the system penalizes people for exercising their right to trial? Should cooperation be required to get a reasonable sentence? These are legitimate questions. The justice system does create an incentive structure that rewards early cooperation and penalizes going to trial. Some argue this is coercive, that it pressures innocent people to plead guilty. Others argue it is necessary, that complex cases cannot be prosecuted without insider cooperation, and that offering reduced sentences for cooperation is the only way to dismantle criminal organizations. I am not here to resolve that debate. I am here to explain how the system actually works. And how it works is this: if you are guilty and you know you are guilty, cooperation is almost always the better choice, not because it is fair or unfair, but because it is reality. Defendants who cooperate early get significant sentence reductions. Defendants who fight and lose get maximum sentences. The defendant yesterday chose the latter path. He gambled that he could win at trial, or at least get a light sentence. He lost, and now he has to live with the consequences of that gamble for the next 22 years. One more thing worth noting: the judge's tone during this exchange was instructive. She was not angry. She was not vindictive. She was matter of fact. She explained calmly and clearly that the defendant had missed his chance to cooperate, that his last-minute desperation did not change the calculus, that choices have consequences. This is how experienced judges handle these situations. They do not gloat. They do not lecture unnecessarily. They simply state the reality. You had opportunities. You did not take them. The time has passed. I have been thinking about this case since yesterday, about the moment the defendant screamed, "I'll tell you everything now," because that moment encapsulates something fundamental about human nature. We convince ourselves that we have more time than we actually do. We think we can wait, see how things develop, keep our options open, and then suddenly the window closes. The opportunity is gone, and we are left screaming into the void, offering things that no one wants anymore because we waited too long to offer them. In criminal cases, this dynamic plays out constantly. Defendants wait to cooperate, they wait to accept responsibility, they wait to tell the truth. They think they can time it perfectly. Cooperate only if necessary. They try to hold information back as leverage. What they fail to realize is that leverage loses value with time. Cooperation that might have earned a 75% sentence reduction in the first month could be worth only 25% a year later. And once you're standing in a courtroom after sentencing, pleading to be heard, it may be worth nothing at all. I'll be closely tracking what happens next in this case. The defendant will likely attempt to cooperate from prison, writing letters to prosecutors, outlining what he claims to know, possibly sitting for debriefings with federal agents. And while it's possible, though far from guaranteed, that truly valuable information could lead the government to file a motion for a reduced sentence, that process doesn't move fast. It takes time.